Welcome to Inherently Distinctive.
Welcome to Inherently Distinctive with attorney Mark Goodman. Mark's practice focuses on patent law, trademark law, copyright law, and business law related to innovation. I'm your host, Sophia Morales, and today's episode is You Got a Cease and Desist Letter, Now What? So welcome back, Mark. I'm so glad to have you here with me.
Yeah, this is awesome. I'm ready to roll. What do we got?
Well, and it's such an important topic. I know you get these things that arrive in the mail, and some of them can be quite alarming, like a cease and desist letter. So, what should be the first thing someone does when they get one of those?
Well, take it for what you will coming from an attorney, but you need to go see your attorney, right? Like that's really all there is to it, right? For something like this, because the evaluation could go in any number of different ways. When you get the cease and desist letter, you're taking into account, here are the things I think about when we get one, right?
Right.
First of all, the strength of their claim. What, say it's patent or trademark infringement, right? You've got to do a full analysis of how strong is their claim against you, right? You also have to think about, quite frankly, who is the other party? Is that party likely to have the resources to take you all the way through litigation if they had to, or are they possibly bluffing? That's another thing to be thinking about. And you also have to evaluate that for yourself. Are you in a position to go through intellectual property litigation or not, right? In which case you may need to be bluffing at some level or dealing, depending on how strong their claim is, right? So it's a very, very expensive proposition if you go all the way. So there's a big game of chicken when these things happen.
Right.
So we could take your entire family on a private jet to Europe. Or we
I
could do
like
a
that.
patent or trademark litigation case, right?
You know what? I want the
In that
vacation,
range.
man.
It is in that range of cost. Okay.
Yeah.
So this is very serious when these things happen.
Absolutely. So when you get one of these, are they all like enforceable, or are some of these not really, do they not carry real weight?
Depends on what we mean by enforceable, right? So
Right.
you could, generally speaking, you don't have to do a cease and desist letter. You can just, somebody's infringing your intellectual property, sue them, right? But most people will at least especially intellectual property, given the cost and so forth. In
Right.
almost every situation, we're going to advise people to send a cease and desist letter first before we go on into the court system, right? So now the cease and desist letter itself often have a deadline, like you need to respond within 30 days of the receipt of this letter or else, right? And it's going to be pressing and all that stuff. And I make fun of it, but I do the same thing, right? But that's not a real deadline like a court deadline, or there's no legal ramifications of that deadline. That's just something coming off of an attorney's or computer nowadays, right?
Yeah, exactly.
So that's all it is, right? So sometimes people overly freak out. Oh my God, I need it, and especially a lot of times I'll get somebody gets a cease and desist letter, and it's like 2 days before the deadline.
Yes.
And then they're like totally, and I have to tell them, like, I'll send the guy an email. I'm representing you on this. Just give us another 30 days. That's almost always going to be fine because nobody really wants to take it to litigation, right?
Right.
So the deadlines aren't real there. And that's important to contrast. If you get served court documents, you're sued. You have hard deadlines where you can default and you can actually lose legal rights by missing deadlines, right? So that's what's hard. That's part of why you really want to talk to your attorney, because, people would assume that if a lawyer's putting a quote deadline in, really what they're saying as a deadline is, we're going to give you this amount of time. And if you don't respond or don't do what we say, we're going to then consider legal action, or maybe they will go for it, depending on how aggressive they are.
Interesting. So what are the risks or the downsides of just ignoring that thing, putting it in the circular file and going, I don't hear you?
So it's like a poker game in some level. I will actually say that in a lot of instances, ignoring it works, right? Now, it only works because the other side may have really been bluffing. They aren't really prepared to go through what it takes to do intellectual property litigation. They just want to scare you into a different position, right? But if you are facing somebody that's aggressive enough and does it, well, you ignore the cease and desist letter, you basically gave up your ability to get this thing resolved without having to deal with the legal system, right?
Right.
And
Yeah.
that can be a big thing. So, I mean, most of the time my advice is not going to be to ignore it, right? You're going to want to
Right.
respond. The only times that where I have said, okay, let's ignore, sometimes it just seems like either the person has like no, it's a total stretch. They really don't have a case, or they're just don't seem like they're really much in business that they would really be a threat to you. In some
Gotcha.
cases, I've been at least okay with clients ignoring it, but that's just not really great practice
Yeah.
to do.
So, how do you evaluate whether their claim is valid or if they're just out being aggressive and like trying to extort you for whatever they could get?
Yeah, so that's going to be has to be a case by case evaluation of it, just like any legal claim, right? Really no different in that regard from any type of your neighbor sends you a letter, you need to move the fence because my property line is there instead of there, or something like that, and
Yeah,
you'd have to evaluate that, right? So it's very
exactly.
similar now. So a couple of things to think about. I mean, if it's patent, you can at least verify some basic things too. They haven't an issued patent? Is it still not expired, right?
Right.
And then you could at least take a look at its claims and see where you think you stand, right? The scope of a patent is determined by the claims, right? And those claims, right? There's usually a whole set of claims, not just one or two, and they can get quite complicated, right? So it's just not easy to do, but you would at least look at the basics of that. Now with trademark, right, it's a little more intuitive for folks because you're really looking at a few main factors, but one is how similar are the mark that the other company has compared to what you're using, and then how similar are the business areas that you're in, right? Because you can have the same mark or something similar if you're in a totally different business area in general, right? So that would be another thing to look at. And also, if there is a conflict, who was using it first? Because maybe you're going to fire back and say, actually, we've been using this way longer than you guys have. Maybe you have your own
Mm.
trademark, hopefully. I don't know, right, depending on the situation, right? So there is not an easy checklist here. You really just need
You need someone
professional
with
services of a lawyer
experience.
that
Yeah.
understands this stuff to figure out what to do next. But generally speaking, the protocol would be a couple of things. If maybe if you think that, okay, they have a little bit of a case, but it's arguable, then fire off your argument back why you're not infringing, right? Or why their intellectual property might be invalid for it. And then you're in a position to maybe make a deal with them, or maybe they just go away, right?
Well, and speaking of make a deal, what are kind of the choices, the options for responding to something like this?
One way would be through the whole spectrum, right? In some instances, you would say, this is complete nonsense, right? And you
Right.
fire off a scathing letter back, basically saying this is totally nonsense here. This is wrong, 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 whatever,
Yeah.
depending on the situation, what you'd say. Then sometimes you might say, hey, we think this is wrong, and here's some reasons, but we want to avoid litigation. Let's get on the phone. Let's talk about this and see what we can do. And maybe if you have a specific offer, let's say, you could propose that, maybe, right?
Right.
And then in some instances, I mean, I've had scenarios, especially where I maybe represent a smaller business and they've got a, let's say, trademark or patent. It's a cease and desist comes in, and they just say, "Hey, I can't have this in my life, right? I just
Right.
want to comply." Right. So then you'd send something back, and okay, we will take down this, or we'll rename this product, or take down this, stop selling this particular product, depending on what we're
What the
talking about,
claim was. Yeah.
and we'll do it, and we'll send you a proof that we're
Complying.
not complying, and that way, you're not, getting dragged through the court system.
Yeah. Okay. What are some of the other options? Obviously, court.
Well, we've already talked about ignoring it, which, like, it's,
Yeah.
has its own pitfalls, right? But, you know, quite frankly, sometimes a lot of people do that, and sometimes it works because people just give up on stuff.
Exactly. Can
But
you pay them money just to use it?
so, okay, in the case of patent, yeah, you can always pay them money if they'll agree to it, right?
Right.
You might say, hey, well, what would it take to get a licensing agreement so we can keep you selling our product that's successful, right? And not have this problem, right?
Yeah.
And that's just full negotiation depending on the value of the patent, the value of the products and that are in the market, right? So, and then in trademark, you can kind of, it's a little bit dicier because trademark's one area where sometimes if you have two marks that are similar enough, somebody's got to yield, right? Because otherwise you have consumers
Confusion.
confused about what's
Yeah.
going on here, right? And so, but in some instances, you can also make a deal where you basically, it's often called a consent agreement, where you're both consenting to the other side having their mark. And typically what you'll do is you'll place restrictions. It's like, well, we can only use it with this branding and we can't do anything that's going to get it closer to your branding. And we're going to only use it with respect to these fields and we won't do anything else. So example, this is a fun one. We can name the
Sure.
client here because it's me, right? So when I applied for the Goodman Law Center trademark and the logo, right? Whoever designed my logo, I don't know, man, but I got a cease and desist letter from Gucci, right?
Oh,
Because the logo, you may want to look at it, it kind of looks like the Gucci
it's got elements, maybe.
enough.
Yeah.
And so I'm like, the last thing I need is some sort of lawsuit. And
With Gucci, no
we
less.
put together a deal there. Probably shouldn't say much more about the deal, but we basically, hey, I can keep using it. There's some other stipulations and different things like that, and we're all good here,
Yeah.
right?
Don't put it on
And I
handbags and
don't, I
shoes.
don't think there's any way that they're going to people will confuse my law firm with Gucci, right? That's
Yeah.
just not going to happen. So they ultimately were cool about it and all good, right? But that's
Exactly.
an example of something that could be done.
So it sounds like there's kind of a range of outcomes on this. How often do you end up in court with something like this?
So I'm not really, haven't looked over things and I'll have to put a number on it, let's say.
Mhm.
Most these things don't go to court, but certainly some of them do, right?
Right.
And it certainly can happen. And it can, and it's not, the legal system. One thing I will say about it is if, it's worth giving up a little bit in most instances to avoid it.
Yeah.
That's what we always want to do is avoid the court system. In some instances, it's worth going to court. I'm not saying it never is, right? But it's just there's always a little bit more of a Pandora's box of just costs and like there is not only is it just super expensive, it also takes a very long time, and you have to also factor in the stress of it. Like just any like in my practice, I practice in litigation. I don't practice litigation anymore, right? So if we're going all the way to the court system, I'll do the cease and desist letters. But if we're going
Right.
to court, I'll get you placed with litigation counsel. But it's just everybody's stressed out, right?
Mhm.
Clients, I mean, and the stress just lingers throughout the entire case. How can it not, right? It's
Yeah.
hard to compartmentalize it because you just don't know the outcome most of the time. It could be
Yeah.
anything from you winning, like in an intellectual property litigation. Oftentimes there'll be counterclaims, right? You could win tons of money from the other side. You could lose from the other side. And these numbers could be enough that it can be a bet the company situation sometimes.
Yeah. So when is it worth pushing back and when is it better to pivot and pursue something else?
I mean, it's always case by case. Here's a couple thoughts on it though, right? Like on the trademark side, one of my analogies is fun vignettes here is that, your trade is analogous in some ways to like, maybe you meet somebody and then you go on a first date and then you're going on a second date and then you're dating kind of regularly and then pretty soon you're engaged and then pretty soon you're married and then you're married with 4 kids and a house and a 401k together,
Yeah.
right? The longer you've been in business and the more business you've done with a certain brand, the more married you are to that brand,
Yeah.
right? So if you're in a situation where you've had this really well established successful brand for a long period of time, there's a really good chance it's worth a lawsuit to defend it or to
Yeah.
enforce it depending on your situation, right? But the flip side is let's say you're a relatively new business, you started some stuff up, and then you get a cease and desist letter from some big company that's, oh, this you're infringing on our brand. Well, if you go on a first date with somebody, the person's crazy, don't go on the second date, right? Like,
Exactly. Cut bait, run.
so just get creative. and do a rebrand, and you'll be you'll be way happier than you would be going through the legal system, especially because in the situation I just laid out, you're probably going to lose, right?
Yeah.
That depends on the facts of the case. So that's what I would think of. Now, on the patent side, it's much more about just an evaluation of how the patent compared to. There's always two responses if someone's accusing you of patent infringement. Number one, our product's different. It doesn't cover your claims, don't cover what we're doing, right? And that becomes a very complicated analysis in the court system, right? So, but you can always make that argument, almost always, right? And then the other thing you might say is, well, we think your patent is invalid, right? Maybe you can dig up prior art that the patent office didn't consider that predates their filing, for example. That would knock their patent completely out in court. So, and there's all sorts of different things when you get involved in patent litigation. The one thing that's a little better, like with the trademark, it's a little easier to kind of understand where you stand. So that's a little bit better. What I will say on the patent side is at least it tends to be, I think, more realistic because you don't have the issue of consumer confusion. So if you can make a deal, you can make a deal, right? I'll give you 1% of sales of all this product, right? Or I'll just pay you an X amount of money for a non-exclusive license to this patent so we can keep going, right?
Yeah, exactly.
So you always have that option. And again, if most people will rather take a deal than go through the system.
Absolutely.
Just the way it is.
So what's your best advice for someone who's a little shook up? They've just gotten one of these legal threats to their IP or their trademark.
So just know if you're in business long enough, you're going to get one of these things at some point, right? It's going to be, so just understand this is part of doing business. Get with your lawyer, figure out a game plan, just go forward with the game plan and just execute just like you would any other business issue that comes up. And
that sounds nice, grounded, relaxing feedback. I like that.
Yeah.
Thank you so much for sharing all this information with us today, Mark.
All right. No problem, guys.
All right. And thanks for tuning in to Inherently Distinctive with attorney Mark Goodman. To connect with Mark, visit goodmanlawnevada.com and be sure to like, subscribe, review, and share with those you care about.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.